him joining.
All right, we're back live for, we had started a attorney's walkthrough of S-103, which is another bill we'll be considering next week. And Damien got through X% of it, and we just wanted to be able to finish the walkthrough, spend a little bit of time asking questions on it, and then hopefully we'll be done. Damien, you think we'll be done by 3:15 or so?
Sure.
Okay.
I think that's definitely doable.
And one of our witnesses, Rachel Seelig, anyway, who is scheduled to be here at 4 because she had meetings, is available earlier. So we're checking to see if Angela Zakowski is available earlier as well, so that we can end a little bit earlier. So with that, Damien, welcome back.
Thank you. For the record, Damien Leonard, Office of Legislative Counsel. So I'm going to go ahead and pull up the bill. Okay, so we're resuming here on section 3, which is on page 6 of the bill. And this takes us into the Public Accommodations Act, or the Fair Housing and Public Accommodations Act. So before we get started, last year we passed some of this language already for fair housing. What you're going to see is in section 4, we've taken all the language we passed last year for fair housing and we've struck it out. And that is because it's being added in section 3, which applies to both public accommodations and fair housing. So that's really what we're doing here, is we're taking what we passed last year for fair housing and extending it to places of public accommodation. So this would define the word harass as engaging in unwelcome conduct that detracts from, undermines, or interferes with a person's. And number 1 here is new language: use of a place of public accommodation or any of the accommodations, advantages, facilities, or privileges of a place of public accommodation because of the person's race, creed, color, national origin, marital status, sex, sexual orientation, gender identity, or disability. A couple of things to note here. First thing is, you're going to notice that the list of protected classes, if you're paying close attention, is different from the list of protected classes for purposes of employment. And if you look down the page, it is also different from, and go on to the next page here, it's also different from the list of protected classes for purposes of fair housing, which also includes things like occupying a dwelling with a minor child, being a recipient of public assistance, or being a victim of abuse, sexual assault, or stalking. Those 3 things we've applied to fair housing, not to public accommodations generally. Part of the reason why we have the different wording is that these laws grew up at different times and different legislatures have used different words. The other reason is that we've had more expansions of our employment law protected categories in recent years than we have with public accommodations and fair housing. So you will see some differences. You will see some older terms such as creed or religious creed. Now we just say religion. But in general, though, they match up pretty closely. I do have a chart that compares and contrasts the 3, which I can provide to the committee if that's helpful, and groups them together by appropriate category rather than the way they phrased it, which doesn't always match up, even though they mean the same thing. The other thing that you'll notice here is just that we use the phrase accommodations, advantages, facilities, or privileges of a place of public accommodation. So the question is, well, what does that mean? So accommodations is pretty straightforward if you're talking about a hotel or a motel. But when we get into advantages, facilities, or privileges of a place of public accommodation, that can mean everything from equal access to the facilities of a state prison to being able to shop in a store on Church Street in Burlington. So these are places that are open to the public. They do not have to be accessible to all members of the public at all times. And then the wording, advantages, facilities, or privileges is construed broadly in favor of the individual who might be experiencing discrimination. So it's a remedial statute. Typically, we construe it to accomplish the remedy of correcting discrimination rather than construing it narrowly to exclude people from its remedy.
When this bill came up last year, it had specifically education as part of the public accommodation, is that right?
We're gonna get to that.
Okay.
So I'm gonna skip over the fair housing piece because it's existing law unless you want to go do a refresher on that. But just to say that subdivision 2 is fair housing and it's taking existing law from one section and moving it to a different section. That's all it's doing.
I'm sorry, can you go back to the notion of the word harass or harass?
Mm-hmm.
This is new language.
So this is new language to the extent that it relates to places of public accommodation. So if you omitted subdivision 1, the language harass means to engage in unwelcome conduct that detracts from, undermines, or interferes with a person's terms, conditions, privileges, or protections in the sale or rental of a dwelling or other real estate. That's in existing law 2 sections later currently.
Isn't this the opportunity to replace the word creed or religious creed?
Absolutely.
With religion?
Yep, we could do that.
This seems like less confusion that way by
Yeah.
using a consistent term.
One thing that I would note is just that I would need to look through the rest of the chapter to make sure that we're consistent. So, because I think it does pop up in other sections and we just need to be consistent throughout. So it would extend the bill, but it's not a hard change to make.
And I'm sorry, creed, you're treating creed as an antique reference to religion.
Yes.
Yes.
Well, and small I says because of a person's race, creed, color. Small double I says because of a person's race, religious creed. So even within consecutive paragraphs, it's slightly different.
Okay.
Certainly not a substantive change.
It is a substantive change. It's a huge change because it's what people are used to, and I mean it stands for the same thing. But I would call it more than a technical change. I'm not demeaning you. I'm
Okay,
just saying.
we're not going to get through this by 3:15.
Yes, we are.
Moving forward. So in subdivision B, we get to the language that we've seen before in the employment, notwithstanding any judicial precedent to the contrary, harassing conduct need not be severe or pervasive to be unlawful. So this is basically removing the severe or pervasive precedent. And then the same language here regarding the guidance to the courts on how to determine whether conduct is unlawful harassment, determination on the basis of the record as a whole under the totality of the circumstances with a single incident being enough to be unlawful, considering incidents in the aggregate and considering conduct based on multiple characteristics in totality. And then the reminder that conduct may constitute unlawful harassment, regardless of whether the complaining person was the individual harassed, the complaining person acquiesced or otherwise submitted to or participated in the conduct, etc. And so that brings us down here. The main change from the employment laws is this. So in the employment law, we say, despite the conduct, the complaining person was able to continue performing their job, or something to that effect. I can't remember the exact wording. So in here, we're saying use the place of public accommodation or any of the accommodations, advantages, facilities, or privileges of the place, or B, enjoy the benefit of the terms, conditions, or privileges or protections in the sale or rental of a dwelling or other real estate. And that again is existing law already. And then again, the last two pieces here, conduct does not have to result in physical or psychological injury, and it may occur outside the place of public accommodation or the dwelling or other real estate. And then C includes the language setting a petty slight or trivial inconvenience as being below the bar for unlawful conduct. And then turning to Representative Burrow's question, D provides that the provisions shall not apply to any of this new language, this new definition, would not apply to any action brought pursuant to the provisions of 16 VSA 570F. So that means what happens with student harassment in a school is that the current law provides that it either needs to be severe or pervasive. When they've exhausted their administrative remedies under the school's policy, which includes that standard, they are allowed to sue under the Vermont Public Accommodations Act. This would say that this definition of harass does not apply to those cases. So there's two things here. One is, if you did apply this definition of harass to those cases without making changes to Title 16, what would happen is the schools would be charged with enforcing one standard, which has a high bar to prove unlawful harassment. But then when the administrative remedies were exhausted, they could be sued under a different standard, which makes it much easier to show unlawful harassment. So in order, the second piece of this is, if you wanted to apply this to the schools, you would want to also modify Title 16, because otherwise you're going to have a situation where schools are charged with enforcing one standard, even though they'll be held to account under a different standard. And so they would be in essentially an impossible position where plaintiffs could just exhaust their administrative remedies and then sue them. So
what about with, I mean, this is a separate question, but what about with employees in a public school setting?
they would be subject to this.
They would be subject to this as it stands.
The bill here, they are employees subject to the Vermont Fair Employment Practices Act. So as written currently, this bill does set up two different standards in a school. One for employees, which is more protective against discrimination, and one for students, which is less protective. So I obviously am not the person to speak to whether this is good policy or bad policy. That's for the advocates that you hear on this. But if you're considering that, there are issues both from the employment law standpoint and the student standpoint there. And you currently have two different laws that impose the same standard. This bill would change one of those laws as it's currently written. So.
Okay.
It was a consideration last year, very much so, until what we considered a fairly last minute conversation that happens where the School Board Association and others came in to state this.
But they now fully support it.
We would need to hear from them directly that that's the case because because they didn't feel that way last year. So let's pin that and make sure that when we take up testimony, we would obviously want. So Damien, if we were to make this so, then we would just delete this section. And then it would, with the, not just the approval, but with our consideration and our thoughts, study on it, that would be making the discrimination levels the same.
Yes, so the language to accomplish that, or at least the initial version of the language to accomplish that is in, I can't remember the bill number off the top of my head. It was introduced by Representative Christie
It was,
this year.
yeah, okay.
So he introduced a companion bill to the Senate version.
Yep.
The Senate version expressly excluded the students. His bill included them. So.
I just have since you're, would it be all right if I asked another question?
Of course. You see me waving down and
Ixnay on the Eston Quay. What if the language was in an amendment that exists right now and hasn't been passed?
So you mean basically an amendment to another bill?
Yep.
So if you were to amend another bill with that language, the tricky thing is that you need to make the two bills line up. So either you need to know that both bills are going to make it to the finish line and be enacted. So go through both chambers and get the governor's signature or be allowed to pass into law without the governor's signature or survive a veto. And so the challenge with that is you could end up, say you send this bill back with amendments to the Senate, they send it back with further amendments, and we get to the last week of the session, and in the rush, the language in the other bill either goes in a different direction or gets dropped in part or whatever it is, or it just doesn't match up. You could end up with a situation where you have law that was intended to match up and it just doesn't fit together. We had a similar situation occur in the rental housing laws several years back, where the language was put into two bills. It was slightly tweaked. And so we had conflicting law that passed in the same year modifying the same subsection, which happened to be a major subsection if you were bringing an action to evict someone. And the courts did not know which version of the subsection to apply because there were two versions that appeared in the green books. And so as a practitioner, you would have to guess and then argue which one, or just pick the one that you thought the other side would go along with. So we want to avoid that to the extent that we can. So ideally we'd get it all in one bill, or we'd find a way to make sure the language matches up and then hope that it doesn't change anywhere along the line. I have one of the earlier sessions, and literally the last bill out that night was fixing a mistake where two ships passed in the night with different language, and we had to repeal and replace the language on like July 2nd. So conflicting language went into effect on July 1st, and then we replaced it all on July 2nd with the last bill out that night. So it's difficult, is the short answer to a very
You had more
discussion.
there.
Not much.
No, but it was a stressful, it was a stressful time.
Yep. So anyway, that could happen any number of different ways. If the student harassment piece was to remove severe or pervasive in another bill, we could just strike this and then hope the language matches up and otherwise do a technical correction next year too. Should just put that out there as an option. But the challenge is if anyone brings a lawsuit and the language doesn't match up,
Yeah, right.
so.
Got it. Thank you.
So like I said before, section 4 here just strikes out the unfair housing practices language from that we enacted last biennium because we moved that all to the previous section. And then the effective date is July 1, 2023. And you have 15 minutes for discussion.
Do you have a 15-minute question?
Probably. So taking off my legislative hat, putting my HR hat on, I have a few concerns and a few questions. If I'm reading this bill correctly, and please tell me if I'm not, with the change from the severe or pervasive language, one instance could trigger litigation. Whereas normally, or in the past, say an employee does something that might constitute as harassment, or they've done something against, policies. As an HR professional, there would be an investigation, a sit-down conversation, and most places, or all places that I've ever worked, have something called, progressive discipline, where it's up to the HR professional or management team supervisors to set forth a plan on how to combat that. That's also fair to the employee who may or may not have made a mistake. I can think of a really great example where I worked somewhere where somebody was consistently throwing things at another employee, and not, chairs or anything, but the pens and little things, and it just slowly drove the other employee up a wall until finally she came forward and said, I can't do this anymore. I had no idea what was going on. And I was able to mitigate the issue. If the bill's language remains the same, obviously it's not necessarily severe, but could it potentially go straight to litigation?
So one important thing to keep in mind is that the employer has to have knowledge unless it's a supervisory employee who's engaging in the behavior. So if the individual throwing things at someone because they're a member of a protected class or engaging in other behavior is a supervisor, then you could go potentially. You could potentially go straight to litigation. There are reasons why an employee might want to try to solve the problem internally, even from a litigation standpoint.
Oh, absolutely.
But if it's employee on employee and the employer doesn't have knowledge of the behavior, that's an immediate defense right there, because as an employer, you can only fix the things you're aware of.
Sure.
So if the employee didn't come to you and make you aware of what was going on, then you would have a defense against liability. On the other hand, if the employee did come to you and you said, come on, this isn't a big deal.
Sure.
And you let it go, and it was discriminatory behavior, then the employee could litigate and the employer could be liable at that point. So I think the issue, the difference between S103 and the existing law is, in the existing law, the employer is potentially liable if they become aware of severe or pervasive discriminatory behavior and they do nothing.
Okay.
Under S103, the employer is potentially liable if they become aware of any discriminatory behavior that's more than just a petty slight or trivial inconvenience, and they do nothing. So that's the difference.
Does the employer have, I don't, it's probably not even the correct term, like first right to deal with the situation internally? I guess that's my largest concern with this, is that a discriminatory action is taken, someone goes to the employer, says this happened, this isn't okay, and the employer is not given the opportunity to put in action their progressive discipline.
I think, again, I mean, it's going to depend on the facts of the situation, but I think, again, if the employer is taking prompt and reasonable action or timely action under the circumstances, that, you know, going to your HR director or supervisor 10 minutes before you file your lawsuit at the courthouse, you know, or while your attorney is on the way to the courthouse with your complaint, doesn't count as giving your employer. I think you can make a very convincing argument in court that we didn't have an opportunity, we just became aware of this. Because those actions do take time. On the other hand, you know, if the employer fails to act in a reasonable period of time, then just like under existing law, the employee may be able to make a claim. The difference is that they no longer would need to show that the behavior they complained about was severe or pervasive. So I think timing-wise, the timing and the process for the employer stays the same. The difference is that the bar for unlawful behavior would be lower here, so that the employer couldn't just ignore discriminatory behavior that they didn't think rose to the severe or pervasive standard.
Okay. Thank you.
Representative Barley, as a human resources professional, you understood that.
Yes.
I did not, thank you.
So basically the difference here is it's not changing. This isn't changing the process to bring a discrimination complaint for a plaintiff. And it's not changing the defenses available to an employer. It is changing the standard for what's unlawful. So some employers or institutions may have a policy that says it needs to be severe or pervasive for us to take action. And their policy just prohibits that. Or they may have an internal policy of triaging the most serious things and letting lesser things maybe slide, or, you know, whatever it is. This would force them to react to everything that rose to the level of discriminatory behavior. That's sort of the practical explanation. So it would change what employers need to do in order to protect themselves from liability. And it would potentially open up a lot of cases where in the past, a plaintiff might not have succeeded in court because the behavior in the court's opinion wasn't severe or wasn't sufficiently pervasive.
And isn't, as a review, because we still have you for 6 minutes. As a review, the concept of severe or pervasive versus severe and pervasive is an argument that's made in some circles. We've heard it before. And also, is this the phrase or the concept that was only talked about in opinion in second district, or is this, so it's not, anyway, can you just give us a quick
Sure.
reminder of
So-
what we're talking about when we talk about or and?
The severe or pervasive standard, that's the legal standard for employment discrimination, was set out by the Supreme Court. It dates back to my knowledge, to the Meritor Savings Bank case, which was the first case recognizing sexual harassment as a form of unlawful sex discrimination. And that was, I believe, 1986. And in that case, they drew the line for hostile working environment. So this isn't sexual harassment saying, you do this and I'll give you that. This is sexual harassment where it is behaviors that create an objectively hostile or offensive working environment. And in that case, they said an isolated incident by itself or a mild incident isn't enough. It has to either be sufficiently severe that one incident by itself creates a hostile or offensive working environment, or it has to be sufficiently pervasive that the repetition of the different incidents or the continual occurrence of them creates this hostile or offensive working environment. Since then, some courts have misstated the standard as severe and pervasive, which, as you can imagine, means that the behavior both has to reach this high severe standard and be pervasive, which is a significantly higher standard. Title IX, I believe, sets out a severe and pervasive standard, and that's educational discrimination under federal law, but that's different from employment law, which is severe or pervasive. And that's the way the standard's been. But because of the way precedent is, little imperfections in the language can build up in the law over time as you pull precedent from a case that misstated the standard, and then that perpetuates itself. And so what's happened is some courts have at times applied a severe and pervasive standard. In other words, well, the behavior couldn't have been severe because you let it go on for a while, but you reported it after a month, so it couldn't have been pervasive either. That was a court opinion applying it where it was saying there was no way to succeed in that case. So, and this is restating, this is taking the severe or pervasive standard and getting rid of it because of some of the, well, one of the reason the advocates for the bill have given is to get rid of that misunderstanding where a higher standard's applied. I hope that was helpful. I can tell
Yeah.
it's getting late in the afternoon.
No, it's just, it is something, just, it's a fine point that we're gonna hear. I presume we can hear about it, and I just wanna make sure that we're used to hearing it because it's easy. I think
Yeah.
you caught yourself how many times last year, with
Yeah.
just saying severe and pervasive, because that just became a norm.
Yes. And in the initial draft of Representative Christie's bill last biennium, I misstated the standard myself. So, and was promptly corrected by the Human Rights Commission and the Attorney General's office on my mistake. But so, yeah, it's often talked about as and, but the actual standard is or. So.
So let's leave this here for now. We'll have, we'll come back to this bill next week. And we'll get witnesses on all sides of the conversation to let us know what they're thinking about this particular bill. But keep in mind, and Representative Burrows, if you have an idea of where that amendment is, again, it's.
Yeah, I know where it is. That's where it is.
Then let's just keep an eye on it and we'll take it into consideration, because if the education end of life is satisfied with changing the law, then, you know, we can see what's in Coach's, Representative Christie's.
Yeah, I think that there are actually, besides the amendment to which I was referring, I think there are probably several different iterations that we could think about. It's not just in or out necessarily, so.
Yep, okay. So, we will have a short amount of time on 103 tomorrow. Sue Minter from
Okay.
Capstone is gonna come in and talk, perhaps just share a little bit of, you know, whatever she can share on 103, on S 103. And then, again, we'll schedule, witnesses, and people have requested certain witnesses, and, hash this out starting next week.
Great.
Thank you, Damien.
Thank you.
Thank you, Daniel. Thank you.
All right, now, next, I'm gonna jump right in. We have, we were originally gonna have a lengthy gap in our testimony, but one of our witnesses had her late appointment scheduled, and so I wanted to have both Angela Zakowski and Zila were able to change their schedules to come in earlier, so I appreciate that. And I think I have Rachel up first to describe full representation, and then Angela, just from your side, the landlord side of the perspective, I'd just like to get your perspective on these two. They're very much in proposal form, but, you know, we've had some testimony from members of the judiciary last week about this, and why don't get your thoughts on pluses and minuses of trying to reinstitute a program that seemed to have worked once upon a time, and also this notion of full representation and what it might mean for court cases that you've experienced. So, Rachel, please join us. Welcome back.
Thank you.
We had a conversation, I'm sure, as you know, with Jean and with Kathleen Burke just a little while ago, starting at 1 o'clock and 1:30. And so we got an idea of what the rental arrearage program might look like, and I think you're here to fill in some of the color there, and then the representation pilot.
Yep. So for the record, Rachel Seelig, Vermont Legal Aid. I did ask if I could connect to the Zoom.
I just sent it.
You just sent it again. Perfect. So that I can share some visuals with you all while I talk. So we'll see if that comes through. But while we're waiting for that, just a little bit of background. Vermont Legal Aid over the past 4 fiscal years has opened 2,455 cases. 3,606 of those have been eviction cases. So that's 35% of the cases that we do. But as we discussed last time, the vast majority of those are cases that we resolve with less than full representation, or that we can provide less than full representation on. So about 70% of those cases, we're providing what we would call counsel and advice, or brief or extensive service, where we're not able to stick with the client through the whole case. But the need for eviction prevention is incredibly high. You all have heard, I'm sure, plenty of testimony about this. HMIS data showed that 4,400 families were homeless in the past year. At one point, the transitional housing program had 1,230 households. And right now, we don't have a plan to prevent return to mass unsheltered homelessness on July 1st. And lack of eviction prevention is only going to increase the move to unsheltered homelessness with stagnant wages, rising rents, and a less than 1% vacancy rate. Rents have gone up in 2020, about the average at the state was $900 a month. Now it is $1,300 a month. That's a 44% increase. Wages have increased 7%. So it doesn't line up. We also know that the pipeline to homelessness is quite strong. When DCF went out and visited folks in the motels last year, they found that 36% had entered homelessness from either renting or even home ownership. So it's not like necessarily folks are finding another place to go when they lose their home to eviction. Let's see if we have, there's the new link. If I can pause for just a minute, I will get some visuals up for all of you.
And just while we're waiting, I misspoke about Sue Minter. She's going to talk about this.
Sorry, that's me. No, that was me. I apologize.
Right.
All right.
Sounded like we were edging towards infinity.
Did it?
Yeah.
It's approaching an asymptote.
Oh, man. Okay. Okay, so what you should be seeing is kind of just a visual of the eviction process and the different steps that we have in that process. When we did our eviction report, which used 2016 data back in 2019, one of the things that we found was that at the notice to quit stage, right? So the very first step where people are getting the letter from their landlord saying, we're not renewing your lease or you violated your lease, 70% of those were based only on non-payment of rent. And one of the challenges we found was that a large number of these didn't meet statutory requirements, but no one, tenants, courts didn't even notice. And those violations could have been a piece of negotiating to resolve the case and have someone be able to stick around in their tenancy. So the kind of broad proposal that we have around what we've been calling eviction diversion, but I think that term has been a little challenging. So today I'm going to call it an Office of Rental Housing Stabilization Programs. We're happy to talk with you all about a name. This is a place where there's a resource for tenants and landlords that's available really at any time for landlords before they file a summons and complaint. And we pair that with a requirement that a notice to quit would advise tenants of the program and the potential to access some resources in order to save the tenancy. It doesn't extend the length of time of cases because there's already a time period that has to exist between when you get that notice of termination, that notice to quit, and when you're going to have to be in court, because we have, depending on the type of eviction, different periods of time that you have to give notice for. And so that gives some time for folks to go to get screened, whether it's for an existing program like the the HOP program or the rent arrears program that you heard about from Kathleen earlier, or even applying for a rental subsidy or other assistance. It's also a way of connecting to the mediation program, to legal counsel. And all of it is in one place, because one of the challenges we have right now is that these things are kind of spread out, and it might mean calling 5 or 6 or 10 or 15 different places to try and get the help that you need. And so having a centralized place to do that with a couple of resource specialists, we think would go a long way to making that much more accessible and much more likely that folks are going to be able to access what they need in order to save their tenancies.
And both open to both landlords and tenants,
Yes.
as it says at the beginning.
Yes. And in fact, I think that's really important. On this slide, we've got some of the resources that do currently exist that people have a hard time sometimes accessing. And those include the Landlord Relief Program and the Housing Improvement Program, which really are targeted towards landlords. And we also have the housing opportunity program on here. And I've had a couple of questions, kind of not in this room, but kind of as we've talked about these ideas in the building. Well, if we have the HOP program, why do we need an initial rental arrears fund? And hopefully you heard a little bit about that earlier today, but I just want to briefly point out that the HOP program is limited in terms of who it serves. It's a maximum of 3 months of back rent. And it's only for folks who are either category 1 homeless or categories 2 through 4 with an AMI below 50%. And so by extending that, by creating kind of broader eligibility processes, either those very low income folks, if they have a landlord who went 3 or 6 or 9 or 12 months before filing the eviction, might still be able to get some assistance from this program. And then those folks who are a little bit higher than 50% AMI, but are still rent burdened, because the minute that you're paying more than 30% of your income to rent, you're rent burdened. And that makes it more likely that you're going to fall behind in rent, would also be able to access help in order to save those tenancies.
I'm sorry, can we take a half a step back?
Yes,
I do not know what category 1, 2, 3, or 4 homeless means.
sure. Category 1 is literally homeless. Category 2 is that you are at an imminent risk of homelessness. Category 3 is that you are homeless under some other federal statute. And category 4 is for individuals fleeing or attempting to flee domestic violence.
Thank you.
Absolutely.
Representative Lamont, did you have a question?
Oh, I was just wondering if, did you send these or no? The slide?
No, I didn't send these, but I will send them so that you have them.
Okay,
in your
thank you.
folder. Absolutely.
Sorry, I just can't look at the screen. It hurts.
I understand. I try and get things early, but sometimes I'm working on it until like.
No
right before
worries.
come in.
It's just that's, it's not you, it's that screen.
Yeah, I know.
Thank you.
What does ORHSS stand for?
Yeah, so that's this Office of Rental Housing
okay.
Stabilization
Thank you.
Programs, trying to clarify its purpose a little bit more than I think eviction diversion maybe has been able to.
Is in this proposal, is this housed within legal aid?
No, so we represent tenants, and our concern with being able to house this internally is that it would create conflicts of interest in terms of also then assisting landlords.
So this would be
So-
Vermont Housing.
So what we've talked about is putting this in Office of Economic Opportunity within state government as a potential house for this, because that's also where the HOP grants come out from. The rent rescue fund that you heard about earlier, the rent arrears fund, that I think, it's essentially what's been done with them before. So I think it makes a ton of sense for them to administer that program.
Thank you for this reset.
Absolutely.
And if I'm not mistaken, this proposal, this general structure is 3-pronged. This is,
Yes.
right, so
So this is prong number 1. In my structure, this is kind of like the overall umbrella, right? Like this is an entry point. Everybody gets told about this, landlords get told about this, tenants get told about this, tenants get told about it again if they're actually facing eviction, and getting that notice to quit, it goes on the notice as one of those required elements. And so this is kind of the umbrella that kind of gets us in the door and says, all right, we've got a tenancy at risk. What are all the programs that maybe could help save this tenancy? And we try and access those as quickly as possible. So I think of this as part 1. If you want to think about this as part 2 or 3, that's fine. I think of this as part 1.
We just heard about another part.
Yes.
Yeah, that's all.
Yeah.
All right, thank you.
So I don't know how much time you really need me to spend on part 2, which is this rent arrears assistance fund, because you had Kathleen come in and talk about it earlier. But this is the program that we would want to see housed at Vermont State Housing Authority, and would apply in terms of, we've moved past the notice to quit. Now you've gotten served with that summons and complaint, being then able to access this fund. I hope Kathleen, and I apologize, I wasn't able to be here when she was speaking with you all, talked about the desire to have Vermont State Housing Authority set those guidelines specifically about exactly when funds could be accessed, and kind of putting in to have them set those guidelines in the statute rather than necessarily putting the specific requirements in statute, so that we can best serve folks as they start coming through the door. I talked a little bit already about the difference between what we're talking about in area median income between 50% and 100%. It really does get us up to those folks who we also sometimes hear about talking about as the missing middle. But again, folks who have higher incomes in the current market very much face being rent burdened. I did a quick little look at Craigslist this morning just to kind of see what was available. I found a 3-bedroom in Morrisville for $2,100. I found a 2-bedroom in Rutland for $2,200. So even though that average rent has gone up to $1,400 statewide, it can cost a lot more than $1,400 to house a family. And so even when you're making more money as a family of 2 or 3 or 4 people, it's pretty easy to get rent burdened pretty quickly. And that's part of kind of the bigger picture of the situation we have in terms of the housing shortage right now.
And again, rent burden, so $2,100 figure for a 3-person place. I mean, you're also, that potentially ignores heat. It's all the expenses that go along with that.
All those utilities,
rent burden
plowing.
includes everything it takes to live.
Yeah.
Not just rent.
And I'll just, I'm sure you've heard these numbers before. If you feel like I should skip them, I can. 76,000 households in Vermont rent. 13,000 receive some kind of subsidy, which means that generally they're paying 30% or less of their income in rent. 38,000 households spend more than 30% of their income on rent. And of those, 19,000 spend more than 50% of their income on rent. And that, again, that increases the likelihood that you are going to fall behind on your rent, because when things are that tight, it's pretty easy to have that one, like the car breaks down or your kid needs dental work and you don't have insurance to cover all of it or whatever. It's, it doesn't take a lot.
Can you give us those numbers again?
Yes, absolutely. 76,000 households rent. Around 13,000 have a rent subsidy, the housing choice or Section 8 voucher, or the terms you might hear for that. 38,000 households in Vermont spend more than 30% of their income on rent, so are rent burdened. And 19,000 spend more than 50%, so they're extremely rent burdened on rent.
Does that represent 19,000 additional people, or is that part of the 38? Is that half of the 38?
I believe that is half of the 38. Yes.
So it's
and
19,000
19,000
at 30%, period.
and then 19 at 50%. Yeah. And we got a lot of data over the last few years because of the rental housing stabilization program and then VRAP. VRAP assisted about 16,000 households. It caused a 400 case drop in the number of evictions filed. It led to another 173 evictions being dismissed. But when the state had to cut back on that program because we were running out of money, what we started to see was an increase in eviction filings. So the rate increased from 25 cases per week before VRAP cut back to just those at 30% MI below to somewhere between 35 and 40 cases a week. Are we at 40 now, Jean? 38 something?
Well, we certainly had weeks where 40
were
cases,
filed, yeah.
but the average is 35.
So that's not awesome, and so that's why we're looking for that money. What we would think about, and I'm sure Kathleen talked with you about kind of the program build out, it would be very similar to what we had with the RHSP program in 2020 in terms of having some expectations of landlords certifying habitability, promising not to do significant rent increases, providing the information needed to do a direct deposit so the money goes straight from the housing authority to the landlord, so that they get their money, and then dismissal of the case. And then on the right-hand side of the screen, some of the things that we would expect VSHA to do, that they would be authorized by an amendment to S100 to do, would be developing a simple, plain language tenant application form, continue the good relationship we've had and referring folks who need assistance applying, that they would make sure that they get all those certifications and agreements and notify the court when people get their money, so that those cases can be dismissed. So that's part two, obviously a much shorter version than I think what Kathleen went over with you today. And then part three is the full representation pilot that we would like to move forward with. On the left-hand side of your screen, more numbers for you. If we want to run this as a 1-year pilot, we think that would cost $526,000. If we can run this as a 2-year pilot, we would expect cost to increase about 5% for the second year, so a total of $1,077,000. This would provide for 2.5 attorneys, a full-time paralegal, and a half-time director to be supervising the attorneys and the paralegal. And what we think is that with full representation, we can increase the number of tenancies saved through negotiation or successfully raising defenses or countering filings. And that this will that we also think, though, that this can decrease the burden on the courts and the overall system because there will be attorneys to be negotiating with attorneys. Back in the 2019 report, landlords were represented in 75% of cases and both parties in 10% of cases. Last year, landlords were represented in 87% of cases and tenants in just 13% of cases. So that creates a lot of mismatch in terms of the ability to present a case, present counterclaims, present defenses, because lawyers know the rules of courts. They know how to present evidence. They know how to examine and cross-examine witnesses, all of those things that are actually fairly technical to have to do that you're not going to learn how to do between when you get your notice to quit and when you have your hearing or your trial on your eviction case. I have an example of one of the answers that we saw during the 2019 report work. A mom wrote in as her answer to the eviction case, "I fell asleep during my ride home from work, totaling my car due to lack of sleep from working a full-time overnight job and being a full-time mommy. Unfortunately, I lost my job due to injuries that kept me from going to work. We always pay late or not, and we will catch up." The problem with this answer that this person tried to do on their own is that it's not actually relevant to their case. It doesn't admit or deny any of the allegations that the landlord put forward in their summons and complaint. It doesn't raise any defenses. In fact, it could be read as an admission that, yes, they did not pay their rent. And that could lead to what's called a summary judgment motion, right? There's no dispute over the facts. I win on the law and you're out. So at every stage of an eviction, landlords have representation. At very few stages do tenants have representation. But at every stage, having an attorney makes a difference. Attorneys can help answer cases more effectively. We can negotiate appropriate rent escrow payments, engage in motion practice, discovery, and again, provide competent representation at trial. This representation in our approach to this pilot would continue whether the rental arrears assistance fund is exhausted or not. So this would also allow us to collect data on the impact of representation with those funds or if those funds are exhausted. And I thought I would turn over to Jean for just a moment to talk about a couple of the cases she's had where we have been able to provide full representation. Yeah, we're happy to answer questions before we do that to kind of give you a kind of clearer sense of how much of a difference it can make.
In the budget proposal that we
Yes.
saw, there were two variations. One was with a director, one without a director.
Yeah.
Can you talk about how viable is it without a director? What's the impact?
It would be a challenge without a director. It would mean we would need to take someone who's already a director of another project and find funding for them to supervise these 2.5 attorneys and paralegal on this grant without using any of this money for that supervision.
So it wouldn't be setting up without a director, it would just be
It would be-
funding a director position
Some other way,
some other way.
bootstrapping as we do.
Director.
I have two jobs, right? Like I'm here with two different hats for legal aid. Like we do what we need to do. But if you want us to do this, really as well as we can, it would be funding it with that halftime director. Yeah.
The, one quick question, I hope, when we talked last week, we talked about possibly using, as a pilot, the same two counties that you used in the 2019 report. Do you have a number roughly of how many cases might be in those two counties?
Yeah. So we are, part of why we are asking for the 2.5 attorneys and the paralegal is because we would anticipate somewhere between 230 and 250 cases in those two counties per year. And that would be at a rate of about 100 cases per attorney over the course of each year.
Okay. And at the end of a pilot program, would there be a report?
Yes. So in the materials that we sent yesterday, with the 3 different parts, we proposed doing interim reports before each of the next sessions, and then a final report at the conclusion of the pilot.
Great. Jean, do you want to chime in?
So Rachel wanted me to tell a story of how an attorney helps in a case at trial, because Judge Tour was saying that at the merits hearing, at the end of the case, that's where we don't have enough resources to be. So I have a story about a trial where I was an attorney and I helped. But the other thing to keep in mind that wasn't in Rachel's benefits of an attorney is we negotiate. We negotiate from the beginning of the case. We make an assessment about how much we're going to litigate or how much we could litigate. And we interview the clients so that we can understand their needs and goals, so that we can negotiate to settle cases. And that's something we do throughout all the stages of the trial. I had a eviction trial a while ago. My client rented from a woman whose main business was being a hairdresser. The reason she owned a building with tenants in it is because her brother owned a lot of buildings with tenants in it. And she thought it would be a good investment. She wasn't really, didn't keep very good records at all. And so when my client would go to pay her rent, the landlord would give her a Post-it note, with received, this much money. At the time of trial, the brother was sort of scandalized, and he retroactively created a ledger from what he thought she would have been entitled to that had no resemblance to facts whatsoever. So as an attorney, I could challenge that evidence, and I did keep it out. It wasn't the ledger made up by the landlord's brother, but rather it was all of the little Post-it notes that my client had saved in actually a plastic baggie. And so at the end of the trial, the judge said, there's simply not enough evidence here to support your claim that she didn't pay the rent. So she wasn't evicted, and she lived there for 2 more years. So that's the kind of thing you can do at trial, which is, it's the plaintiff's burden to put in a case. So you challenge the case that they bring, and there are landlords who perhaps, I know Angela's listening, perhaps are mistaken about their grounds for eviction. So that's my story.
Thanks, Jean. I think the other piece about negotiation is over these past few years, I feel like we've gotten to know across our attorneys who do this housing work, the landlords a lot better. And so have developed more of a working relationship, not just with Angela or with others who do this work, but with the landlords themselves, and have seen, a lot of folks really desiring to keep their tenants and just needing to get paid. And so I think the combination of these 3 programs, right, having that rent arrears fund, having that centralized resource office, and then having, attorneys to negotiate in order to keep people housed, think all of these really actually do meet the interests that we all have of keeping people housed, making sure landlords get their rent, get paid so that they can maintain their buildings and have that income. And so it's to me, this is very much of benefit to the whole system, not just to one party or the other.
Okay, further questions for Rachel or Jean? No, thank you for bringing it forward and for fleshing it out.
Absolutely. And I'll email these over to Ron right away so that you have the
Yeah.
visuals. And you do have the materials, the kind of proposed language materials from yesterday that Jean sent over.
Yeah.
So, and I'll stick around while you hear from Angela.
All right, thank you so much.
Thank you.
Angela, welcome back.
Thank you.
Hopefully you've had an opportunity to review some of the material and listen into the proposal as made by the other VLA, Vermont Legal Aid. And just wanted to get your thoughts on it and anything that you can share on what we're trying to do here. We're just trying to prepare for, well, we're trying to continue or go back to a successful program that seemed to help, but also try to make it a little bit more systemic than reactive. Just wanted to get your thoughts on it.
Certainly. For the record, my name's Angela Zajkowski. I'm the director of the Vermont Landlords Association. Though based on the testimony today, I'm wondering if I shouldn't be here with my lawyer hat on, because I also am a lawyer and I have a law practice where I represent landlords in eviction cases around the state of Vermont. And I think that's sort of more of what we're talking about today. I think what we've seen through the pandemic for sure is there is a need for rental assistance in the state of Vermont and some sort of sustainable program for assisting tenants and keeping them out of evictions. The 2019 report about the rental arrearage and what it would take to stop a significant number of non-payment cases, I think we saw play out with our rental housing stabilization program, and then again with the VRAP program the last couple of years. So, I think as folks are looking at where to put resources and where the biggest help will be, I think the more resource we can provide to that rental assistance piece, the better it is, right? That's direct money to tenants to help retain housing, to save housing, to assist with rental problems and issues related to rent. I think, I've seen it in my own practice. I know the folks at Legal Aid have seen it. It's, a car breaking down. It's a medical issue. It's missing work for a couple of days, and very quickly a non-payment situation can snowball and can get away from a tenant. And once they get behind, it's very hard for them to get out of that. So I think, I'm happy and encouraged that we're talking about creating sort of additional rental assistance for folks, because I think it is needed. Of course, the devil's always in sort of the details and like, how does that look and how do people access it and what restrictions are in the program. I think some of the things that we have learned from our prior two rental assistance programs is the easier it is to fill out the forms, the more participation you get, and that being a completely tenant-driven program like VRAP comes with some challenges. So for both landlords and tenants, being able to access money or initiate processes is incredibly helpful in that regard. So I'm kind of excited that we're talking about this because I think it's good. Looking at this new Office of Rental Housing Stabilization Services. Again, I think we have so many programs and they're all over the place. If there's, a central place where landlords or tenants can go to find out about all these programs, I think that becomes more efficient. The challenge is always, where does this get housed? Who is managing that? How did they get the information of the different programs, and making sure they have accurate information that they can they can give out. I know 211 acts somewhat in some capacity with some of this information if they're provided with the various programs or information. But I think, having a central place where people can call and know these are the options available to me would be definitely helpful for both landlords and tenants, because there are so many new programs out there that I think people are missing because they don't know about them or a way to find them or track them down. In terms of attorney representation for folks, I think, we've seen some benefits to the rental clinics that are, I have, I think, some concerns about the numbers. Again, this is, money that goes to programs and administration is less money for rental assistance. And I just wonder if there's a more streamlined approach to that, to providing, numbers we were given 230 to 250 cases. That's if representation was provided in all of those cases. And I think there were some parameters outlined in this that would make it so not all tenants would qualify for representation, or some will decline representation. And so, I think there's a balance there to maybe make it accessible or available to folks if they want. And maybe there's, compensation for that, but that's not sort of whole host representation as if you are going to handle all of those cases. That's I think, some of the details in the specific proposal, a requirement that things go into termination notices, I will say that gets very tricky. So termination notices are what are called jurisdictional. And so that means if all I's aren't dotted, T's aren't crossed, basically if the notice is not perfect, the court can dismiss the case. Hang on, I'm being handed some of those lawyer papers that my legal assistant is telling me absolutely have to get signed to go in the mail today. So my apologies to the committee.
Breaking news.
I know, breaking news. Lawyer has to sign legal papers.
Now.
And you're reading them all carefully before you do so.
I have already read them. They were being placed on official letterhead for me. So my apologies, folks. Thank you for that brief interruption.
You would have never been able to do that if you were here in the building. So.
I know, right? The advantages and disadvantages of Zoom.
Yeah.
So notices are jurisdictional, which means that if there's a defect in a notice, and it could be something as simple as a misplaced word or something that's not exactly perfect, the court can dismiss the case. And we've seen a lot of cases dismissed because landlords have, missed something, or they've read the statute. So they've read Title IX, Chapter 137, and they think that they've covered all of their bases, but there's all of these other requirements that have developed to go into these notices that aren't in statute. And so it's one of the only areas of the law where if there's something slightly wrong with your notice, your case gets dismissed. In pretty much every other civil case, there's ways to fix things, or there's ways to say, oh, it was sort of close enough. We understand the intent. Everybody understands what's happening here. And so there's very strict requirements for those. And so I would have concerns if we are going to require that folks provide notifications in these notices, because if something's not quite perfect, it means the entire case gets dismissed. Why am I concerned about this? It doesn't mean the issue goes away for that particular tenant. It just means by the time the landlord comes back again, the tenant owes even more rent and is even further behind, or has now created there's an even bigger problem at the property. And so I would have some concerns if we're modifying requirements for these notices. Do I think it's a good business practice to include that information? Absolutely. But I would have concerns if it was a requirement, just given how those notices are treated by the court. And I think partially because this is a new proposal. It was unclear whether tenants could qualify for the rental arrearage portion with a termination notice, because in one place it said you could come with a notice and another place said you wouldn't pay until there was a summons and complaint. And so I think, there's some points like that that would need to be addressed or fully investigated. I would argue that that tenants could access the program with a notice, because what we're trying to do is avoid going to court. So that we shouldn't make people wait till they're in court to access these programs. So,
Simple little things like that, yeah.
yeah, I think there's some, smaller details that would definitely need to get worked out or sorted through. And, I think myself and members at Legal Aid have a pretty long history of being able to work on these kinds of issues kind of behind the scenes to find something that everybody can agree to. And I'm always happy and willing to do that. So.
No, I think that'll be very helpful moving forward, because again, it's about, my experience with this law is about balance and making sure that there's not, just making sure it's balanced, as enough said, that issues like this, that as you're describing, are dealt with or worked on so that everybody feels like they're getting the fair shake.
Right. Right. And that's what I would ask for my landlords, is that that whatever program is developed is balanced and takes into consideration concerns of landlords, which we saw, sort of putting my lawyer hat on. We would see VRAP applications started. Tenants would come in for a rent escrow hearing or some other type of hearing in an eviction case and represent to the court. I've put in an application, and many times they had started their application with VRAP, but then they wouldn't finish the application. And so cases would stall, the process would stall. Landlords wouldn't always get notification from the housing authority that the tenant application had been denied or that they were not proceeding with the program. And so it would cause some pretty significant delays at times as landlords were patiently waiting for VRAP applications to go through that never happened. So I think, there needs to be some controls in place for situations like that we saw with VRAP, particularly if we're going to stop proceedings or require that action in a case not happen if an application is pending. I think we can learn from these two prior programs and sort of take the best bits so we have the best program.
And I think that's what our goal is, is to not denigrate the VRAP program overall, but just to understand, and as we heard this morning from Kathleen Burke, how the limitations that were put on that program versus the original rent stabilization program really created a gap and in the work that landlords and tenants and these respective associations were doing together to make sure that in the middle of a crisis that was being exacerbated anyway by pandemic, that people would be made whole and would be allowed to be housed, or would stay housed. So
right. And I think, there's a lot of data there between the two programs. I think one of the things that surprised me from our first program, so the rental housing stabilization program, which was with CARES money and completely Vermont created program with very little rules from the federal government. So we were able to kind of design a program that we thought would work well. There were sort of two tracks. There was the landlord and tenant apply together. And so that was for 100% of the rent. And then there was a track where the landlord could apply just on their own, but they would only get 50% of the rent. And when the landlord applied on their own, they had to indicate why they were applying, because there was some question as to why landlords would use that second track. when I looked at those reports that came out or with that information, a substantial majority of those landlords were applying for that second tract because they couldn't get the tenant to respond to sign the paperwork to go track 1. So it wasn't because they didn't want to do track 1, it was because it was the only avenue available to them.
Sure. And I think that's the nature of the relationships. But again, what happened with VRAP is that it made applications tenant only.
Right.
The other pieces of the rental stabilization was if the landlord and the tenant agreed that there would be a limitation on future evictions or moratorium of sorts on future evictions, whereas that would not be the case in the second track.
Right.
That's stuff that we can keep working on. Representative Chestnut Tangeman.
I think I know the answer to this, but I just want to clarify, and this could be to any of you. But the settlement doesn't necessarily mean, does settlement mean a ruling, or does it mean just an agreement between parties?
So a settlement or a stipulation, which is sort of the legal term that lawyers will throw about a lot, is an agreement between the two parties that is then submitted to the court for approval. And I can't think of a time, I'm sure there have been settlement agreements that have not been approved, but the ones that I've submitted the last 2 or 3 years and the ones prior to that have been approved by the court. So I don't think that I've had one that's been rejected, but there still is a court sign off that has to happen when you provide a settlement agreement to the court.
Thank you.
Mm-hmm.
All right. Any further questions right now? So I don't know if you, again, in classic State House fashion, if you would like to reach out to each other. We will, I'm not surprised, but that it's more complicated than, a simple proposal. But we will be unlikely to address this in S100 due by Thursday, but as an amendment or within H391 to work on it throughout the course of the year and then be able to amend the S100 as moves on, or another housing bill as it moves on. But because I want to get this, as we move forward with this, I want to get it right. So, or as right as we can. And I know it's still a limited amount of time, but it sounds like we're not approaching this from the North and South Pole at all, so.
And I think for clarification, it's Jean Marie and I have already sort of been in contact about this morning. Would the committee's preference be to work within the proposal that's already been submitted, or is that going to be put into, like, through Ledge Council into a bill document? Like, what's the format that the committee would like us to work on?
If there was a way that you can work together first to have points of agreement, then we can bring this to Ledge Council and then go. It's very, Ledge Council is unfortunately still overwhelmed with what we're throwing at them, and so I would like to work with a series of points, draft language that then they could reinterpret into. It doesn't have to be finished or fully agreed to, but just something that's a little bit more than what VLA and VSHA sent yesterday or sent this morning, but a little bit less than perfect.
Okay.
Just a little bit.
Unless you want to be perfect.
That's right.
Feel free.
But if this is, I'd like to do it this way rather than get our attorney right on it. I'd rather give him a little bit more of a finished product than, so let's try to aim for that. And again, the only time frame I can give you is as soon as possible, or as soon as practicable. And know that we'll be focusing on it as because there's other work and other testimony we'll have to take on the concept as well. So But thank you so much for your time. I really appreciate you taking a look at this. I mean, it seems like it's new and fresh, but it's really, A, it's been done recently, and B, it's been asked for through that eviction, through the years preceding the eviction report. So I appreciate you putting your time together and coming up with a proposal. Thanks.
Thank you.
And committee, I think that's it for today. We'll be here tomorrow morning. The schedule is kind of fluid for the next couple of days. We'll get people in. And we'll keep working towards Thursday evening.